Good morning, Ms. Van Rhyn.
Progress.
Good morning, Chief Justice.
How are you? Well, it's actually good afternoon now.
Good afternoon.
I didn't realize. How are you this afternoon?
I'm well, thank you, Chief Justice.
Yes. Thank you for making yourself available for consideration for appointment as a judge of the Free State Division of the High Court. We appreciate your making yourself available.
Thank you.
I am going to ask you some questions and will then later on allow the acting judge president to ask you questions, and then the representative of the premier, who is MEC Kabate, to also ask you questions. And after that, I will allow other commissioners who may wish to ask you questions. Is that fine with you?
Thank you, Chief Justice. I understand.
You don't mind being asked questions by so many people?
I don't have any choice at this stage.
Because you want to be a judge.
I do.
Okay, no, that's right. That's all right. I see that in terms of the questionnaire that you have filled, you hold 2 degrees, a B. Juris degree, which you obtained in 1984 from the University of the Free State, and an LLB degree, which you obtained in 1987 from the same university. And then in addition to that, you have an advanced diploma in labor law, which you obtained from the University of Johannesburg. Is that correct?
Recording stop. Recording in progress.
That is correct, Chief Justice.
Where does that come from? It's not going to come back again. Okay, all right. Thank you. And you started your working life as a candidate attorney in 1986, is that right?
That is correct, Chief Justice.
And you finished your articles in November 1989?
Yes, Chief Justice. The period at the other attorneys included, yes. The second firm of attorneys, yes.
Yes. And did you get admitted as an attorney in 1990, January 1990? When did you get admitted as an attorney?
1989. I'm correct?
You were admitted
No,
in
1990. I apologize, 1990, the next year.
Yeah, well, if you ask me when I got admitted, I wouldn't make a mistake. It was a big day to be admitted as an attorney.
Yes.
Okay, all right. Anyway, you then spent some time with Symington and de Kock attorneys in Bloemfontein, is that right?
That is correct.
Was that 1992 up to 1993?
Yes, I left Symington de Kock in December 1993.
Yes. Did you then do pupillage in 1993 and got admitted as an advocate?
I did. Yes, yes, Chief Justice.
Why did you leave the Society of Advocates, the bar, and went to the independent bar by any chance?
That was in 1999. I resigned as a member of the Free State Society of Advocates, and the main reason was financial reasons. At that stage, as a junior member of the bar, we all started off with pro deo work.
Yes.
That is when the state appoints counsel on behalf of an accused in a criminal matter, and at the end of each week we were paid by the state at the registrar's office, and the next week you would submit your next account. But at a certain stage, I'm not sure exactly when, after 1994, it changed, and the Legal Aid Board took over those instructions, and then problems ensued with payment. And at the stage when I resigned at the bar in 1999, I didn't receive any payment for more than a year, and I just had so many financial issues that I didn't want to encounter further bar accounts and the responsibility of paying bar fees with those financial problems. And that is the main reason and the only reason why I resigned. It's for financial reasons.
You spent about 11 years or so as a member of the independent bar. Is that right?
Yes, that is correct. I only rejoined the bar in 2011. At that stage, I was already married and decided to continue with practice at the bar.
Yes. Why would it matter? Why would your problem arising from pro deal work make a difference in terms of your financial situation, whether you were in the independent bar or with the Society of Advocates?
The reason is the bar account, the financial responsibility while you're a member at the bar to pay your monthly fees due to the bar.
And if you are a member of the independent bar, you don't have to pay anything?
You didn't? No, we did pay, but it's a minimal fee.
It's minimal fees?
Yes.
Oh.
Just to be a member of a society. I practiced from home. I didn't have the expenses of rent of an office and bar fees, which includes the personnel at the bar.
So you practiced from home?
Yes.
For about 11 years?
Yes.
Okay.
Yes, Chief Justice.
And members of the independent bar, they get briefs from attorneys?
They do.
Yeah.
Yes, I did. I never had a trust account. Those provisions only started later, and not at that stage. No, it was, you
Yes.
had to take instructions from an attorney.
And then you went back to rejoin the Free State Society of Advocates in 2011, and you have remained a member
Yes.
thereof to date.
Yes, indeed so, Chief
All
Justice.
right. This means now you have been in practice as an advocate for close to 30 years?
Actually started in the beginning of January 1995, and until presently it's 27 years.
I'm looking at your questionnaire where it says you became a member of the Society of Advocates in 1993. On page 5 of
Yes,
your questionnaire, or page 3 of your questionnaire.
But that is the year that I did the pupillage. That is the year, 1993, that I did the pupillage.
Yes, but pupillage at that time was like 6 months or even
Yes.
less.
Yes.
But after pupillage, you started practicing immediately, didn't you?
Yes, I did.
So that means you have been practicing as an advocate for about 29 years?
28.
28.
Yes.
That's quite a long time. Eh?
Indeed so, Chief Justice.
Yes. Have you taken silk?
No, Chief Justice, I haven't. The how it works at the bar is that the most senior member on the junior list is the next member to take silk. That is the procedure that we follow, the tradition that we follow. It does happen that a member who's not the most senior on the junior list will apply, and currently I know there's 2 applications that we're waiting for the whether they will be appointed as silks. But currently, and I do have the list with me, I'm currently the 13th member on the junior list from the most senior on that list. So I've not been under pressure to take silk.
If you are not appointed as a judge, how long would you still have to wait more before you get your turn
It's
to
difficult
be silk?
It's difficult to say because, as I say, there's two
There are
of my
2
colleagues who's now waiting. So then it's 11, and it depends on what happens with the other 11 members then above me on the list.
There are 11. Are there 11? Did you say 11?
Well, if
Above
currently, yes, currently I'm number 13, but I know there's 2 that's waiting for their latest patent.
When you say there are 2 waiting, is it 2
Yes.
of
2 of the junior members.
Yeah, but did you say that there are about 11 ahead of you who are more senior to you that you have to wait for?
There's currently 13 members. I'm number 13 on the list.
You are the most senior.
No.
Junior. You are the most senior of the juniors.
No, definitely not.
What are you? How many members are more senior than you?
Chief Justice, we currently 70 members at the Free State Bar. I've got the seniority list with me. There's 70 members in total. The senior list is separate. They are 11. Just make sure about my stats. 11 members on silks. No, 12 members. I've counted them. 12 members are senior members. Then there's the junior list. I'm number 13 on the junior list.
There are 12 above you.
Yes, but
Yeah.
there's 2 who's currently waiting to hear whether these applications will be successful. If they if they've been successful, their applications, and be appointed as silks, then I will move up 2 places. But I'm not sure whether that will happen.
What is your experience in terms of how many take silk in 5 years, more or less on average? Or per year, whichever is easy to work out.
Maybe 2 per year, because it takes time. Sometimes members wait for 2 years before they receive the answer. A further aspect, if I may elaborate on that, is taking cognizance of the number of members at the bar, the Free State Bar. We're 70 members with 12 seniors. That is a good ratio between seniors and members, because this decision to take silk may have an impact on your income, of which the outcome is not certain. So I haven't been pressurized at this stage to consider that option. I'm comfortable with the situation. And a further aspect, if I may say so, is since 2018 I've been acting for approximately...
Continuously?
No, for approximately...
Intermittently?
Yes, 2 terms every year approximately. So I haven't been at my practice.
Well,
That's also a factor that I take into account.
well, I would have thought that acting should enhance your prospects of taking silk.
Yes, I agree, but my work at the bar has diminished
Yeah.
because I was not available for
Yeah.
many months.
You see, part of my concern about you are the second candidate we have interviewed today who who took silk after more than 2 decades. Well, the first one has taken silk, but
Yes.
he took it, I think, around the 28th, 29th year of practice. And you said 28 years now.
28 years.
Yeah.
But
I mean, I know some members of the bar who took silk after 11 years of practice, 12 years of practice.
Yes.
I even know somebody in Durban who took silk, I think, from what I was told, after 7 years
yes,
of practice. He was terribly busy and was considered very good. He was very busy. So when I look at 25 years, 26 years, 27 years, it just seems
strange.
strange, yes.
I understand.
Yes.
If I may
Yeah,
add
okay.
another point, Chief Justice, it's the seniority list at the bar is according to the number of years practicing at the bar. So the period that I was not a member of the bar has also been has to be
Or when you
taken
were-
into account. So
Yes.
if I can explain it.
So
it's-
according to them, your seniority is minus 11 years.
Yes, exactly.
Yeah.
Exactly.
Which would mean you, according to them, you have about maybe 17, 18 years of practice.
Yes, yes.
Okay, all right. Anyway, you have been practicing for many years by any account as an advocate. Tell the commissioners, the branches of law, that the cases you have been doing fall under.
Initially, as an attorney, I started with the litigation, but more delictual claims, motor vehicle accidents, medical negligence claims, RAF matters. It was even before the RAF Act. Then my mentor at the specific firm of attorneys left, Symington de Kock, and he went to the bar, and he convinced me to also join the bar. And that was the main reason why I went to the bar. And at the bar, we usually start off with pro deo work, as I've explained already. That was my bread and butter initially, is to do criminal work also in the magistrate's court. And then the other aspect in the beginning is also the motion court, unopposed motion court. Those days, the judges assisted us a lot by allowing the junior members of the bar to do the pro deo cases, the criminal cases, and then on Thursdays to take unopposed motions, do the unopposed motions first, and then continue with the criminal case, even if we start an hour late. But the work in the unopposed motion court was very important to start your practice in civil litigation. You get exposure and you meet the attorneys while appearing in the unopposed motion court. I would say it's the stage where you get exposure. So that was initially I continued with criminal work for a long period, and that's where the financial problems ensued, which caused my resignation at the bar in 1999. After that, when I was practicing from home, I continued with the criminal work, but it was possible for me to wait for a longer period to obtain payment, because I didn't have the responsibility of a bar account every month. And with further experience, you tend to get more civil work. So with time, I did less criminal work and more civil work. Opposed motions, Rule 43s, divorce matters, those kind of cases, and also delictual claims, medical negligence matters. I appended one of my judgments in a medical negligence matter, because those are the matters that I started off while being an attorney.
Did your practice involve administrative law cases?
Yes, at the bar I did a few review matters, and then even more so since 2018, when I was appointed as an acting judge. We do our review matters on a Monday. So,
And
several.
in your practice, do you have constitutional law cases?
Not that many constitutional law cases.
Commercial
out
law?
and out, I beg your pardon.
Commercial law, do you also
Commercial
have that?
law in the sense of
In your practice?
contracts, yes, contract law, and also regarding insolvencies and liquidations, actually, but not specifically in commercial law as such. Regarding the constitutional law in the Free State, there's not that many cases which consists of constitutional law out and out. But it doesn't mean that I did not get confronted with constitutional issues. For example, in a criminal matter that I did during the last term, I had a situation where the accused put up his hand the second day of the trial and indicated that he's not feeling well. That was not, it was a murder case. The case didn't involve constitutional matters, but at that stage, the accused right to a fair trial, the accused right to obtain medical assistance. So I'm trying to explain that we get constitutional issues daily. You're confronted with those issues, but at the end of the day, the trial or the application does not involve exclusively constitutional issues.
Yeah, well, you are the second candidate to tell us that there is not much constitutional litigation in the Free State, so maybe the Free State provincial government is very compliant with the Constitution.
Chief Justice, I have to explain that in the list of reserved judgments, the one judgment that I listed, I think it's the last judgment on the list, that matter was out and out a constitutional issue. It was for an interdict, but it involved constitutional issues. But at the end of that matter, and that was the arguments on behalf of the respondents, the applicant didn't have locus standi to bring the application, and that my judgment involved that aspect.
Yes, okay, no,
so
that's
we
fine.
do get confronted with constitutional issues, but thus far, I'm actually glad to hear that I'm not the only one.
Yes. Now, how long have you acted in the High Court if you add up all the acting stints that you have had, more or less?
The terms, I indicated the terms in my questionnaire. The first appointment for acting position was during April 2018 to the 27th of May. That was a period for 6 weeks. It was when Justice Molamela requested me to accept the appointment during 2018.
Well, you do set it out there, but
Yes,
I hope...
exactly. 3 weeks thereafter,
Hang on. You do set it out there, but I was hoping you could give a total amount, whether in terms of months or weeks, even if it's not exact, just to give the commissioners an idea of how much exposure you have had as an acting judge.
Yes, understand. What's not included
You didn't work it out.
This, understand, Chief Justice, I apologize. What's not included in my questionnaire is the first term also this year. All in all, because there were several periods with part-heard matters that I had to...
It does look like...
8.5 terms.
It does look like on the face of it, it would be more than 6 months to say the least, but probably much more than that.
No, definitely more than 6 months.
Maybe it's close to a year if you put all the periods together.
Yes, I've calculated 8.5 terms, so that's actually close to 2 years.
Yes, no, that's fine. So when you are acting in the High Court, when you were acting, did you sit in criminal trials as well as civil trials and motion court, all of that?
I did.
Both opposed and unopposed motion court?
I did all the aspects that a judge
You did everything.
get confronted. Yes, I was. All the matters were allocated to me. Also, tax law matters, but that matter didn't proceed.
Yes. And how many written judgments have you been able to produce as an acting judge, more or less?
Chief Justice, I inquired yesterday from the Registrar's Office at the court in Bloemfontein, and they informed me, according to the reserved judgment list, because that's the only statistics that's been kept at court, there's approximately 70 judgments.
17?
No,
or 70?
70.
Okay.
And according to their statistics, it's 7 or 8 criminal matters and the rest civil matters, and also appeals. But it's only those appeals that I penned, not that I...
Yeah, no, that's fine.
So it's about 70.
Yes.
That does not include the extempore judgments.
Yes. And when you have sat on appeal and you are asked to set aside a factual finding of a trial court, under what circumstances would you set aside a factual finding, or would you interfere?
With a factual finding on an appeal? A court of appeals powers to interfere in a factual finding is limited, because it is presumed that the court of quo's factual findings are correct. It's only when the record shows that the presiding magistrate or the judge made an error regarding the facts, and that the factual finding was clearly wrong, which amounts to a material misdirection. I think the aspect is to decide whether an error made was material or not. For example, if in a criminal matter a magistrate found that the deceased died due to bullet wounds when the accused fired 5 shots with a pistol held in his right hand, and the record shows that the deceased died due to 4 bullet wounds due to the accused firing a pistol held in his left hand. That would not amount to a material misdirection. So it depends on what is evident from the record.
And if you were sitting on appeal and you were considering whether to uphold or set aside a decision made by a lower court in the exercise of its discretion, under what circumstances would you set aside such a decision?
When a presiding officer has a discretion concerning a certain aspect, often in practice it's regarding costs, it will be necessary to ascertain when sitting on appeal whether the judicial officer or the magistrate or the court of quo came to the decision not arbitrarily, but based on the facts, the issues, the relevant legal principles. For example, regarding costs, the general rule is that cost will follow the result. So if the applicant is successful in his application, then if the magistrate said no, the applicant must pay the cost, that will be a reason if there's no other reasons or for the conclusion reached by the presiding officer. So it depends on whether the finding was based on the principles and the reasons for this particular decision to decide whether the discretion was exercised judicially.
And what is the test for granting an interim interdict? Or what are the requirements for an interim interdict?
The requisites for an interim interdict is whether the applicant has a prima facie right, whether there's an injury actually committed or a reasonable apprehension of an injury, whether the applicant is able to obtain substantial redress by any other means, and the last of the 4 criteria is whether a balance of convenience favors the applicant.
And what are the requirements for the granting of a final interdict?
For a final interdict, there's 3 requirements. That's the Setlogelo versus Setlogelo matter. The first requirement is now it's on a clear right, whether the applicant has a clear right, not a prima facie right, and then the next 2 are the same, whether the applicant has substantial redress in any other means, by any other means, and whether there's an injury actually committed or reasonable apprehension of injury, and all three those requisites must be present.
Are there any reported cases in which you appeared over the years as a practitioner? In other words, cases in which you appeared which resulted in reported judgments?
Chief Justice, I know of 2 matters, and I've listed them in my
in the questionnaire.
Yes. I don't know of any other.
And the judgments that you have written as an acting judge, are there any that have been reported in the South African law reports? Or no?
No, not as far as I know. I haven't heard anything.
Yes.
No.
Okay, I will now allow the acting judge president to put questions to you, and she will do so, and the MEC will do so, and the commissioners will do so with due regard to the selection criteria that are used by this commission in considering candidates for various positions. They include whether or not you are appropriately qualified, whether you are a fit and proper person, and whether your appointment would help reflect the racial and gender composition of South Africa, and whether you are a person of integrity, whether you have the necessary energy and motivation, whether you are competent technically, and whether you have capacity to give expression to the values of the Constitution, whether you have, you possess appropriate potential, and what message your appointment would give to the community at large. I didn't mention all of them, I just mentioned some of them. So they will ask you crisp questions, and I would urge you to try your best to give crisp answers and deal with the questions as briefly as possible. AJP, please go ahead.
Thank you, Chief Justice. Good afternoon, Ms. Van Rhyn.
Good afternoon.
How are you?
I'm well, thank you, Deputy Judge President.
Thank you. You've already indicated that you acted for about 8.5 terms.
Yes.
How did you find this period of acting? Has it prepared you for the position that you are applying for?
Without a doubt. I've gained a tremendous amount of experience through my acting stints. I learn every day. No, it's definitely prepared me to apply for this position and for hopefully obtaining such a position at the bench. Different matters were allocated to me during this period. Initially, I didn't do any motion court work with my first acting stint in 2018. As time progressed, I did motion court almost every term. The last term, 2021, I did motion court the first week of the term as well as the last week of the term.
So, how many times did you do motion court?
During this period since 2018, according to my calculations, 7 or 8 times.
Thank you. At the time you completed your questionnaire, you mentioned that you had 5 reserved judgments.
Yes.
Have they all been delivered, and have they all been delivered within 3 months?
Yes, they've all been delivered within the 3 month period, the one on the last day. It was an appeal regarding the last term when I also acted. I've got 1 reserved judgment, and it will be delivered soon, next week.
And that judgment you picked up during the last term?
During the
first
last term,
of
yes.
the-
I've got no reserved judgments for the time stated in this application, in this questionnaire.
Thank you, Ms. Van Rhyn. Thank you, Chief Justice.
Thank you, AJP. MEC?
Thank you very much, CJ. I'm going to have just one question, but I want to make a statement before that. Dumela me Van Rhyn?
Dumela, Commissioner. Likai.
Ha monate le kae?
Kgotso.
Ke a leboha. Advocate
leboha.
Van Rhyn, let me start by thanking you for making me to understand something that has been bothering me for so long. I've been asking myself, why should lawyers be taking a period so long, as ancient as the dinosaurs, before they can be senior counsels and before they could be judges. Your explanation and that of the other candidate has made me to have some sense of this glass ceiling that we are trying to break. What is the cause? It was an eye-opener. Thank you very much. The question for you will be, you know, when you apply for a position, you research about it, you sit and think about it, dream about it, all the challenges that are there, and try to have a plan on how to then resolve the challenges that you know that you are going to meet. And
Yes.
you have been serving in the Free State benches. Now, you, can you tell me about 3 main challenges that you know about the Free State Division, and what would be your plans and strategies to resolve those challenges? Thank you very much. Thank you very much, CG.
Thank you. Maybe just one aspect regarding the question of taking silk. It's not, practicing as an advocate is not like going to school but never reaching grade 12 by not taking silk, a senior status. It doesn't work that way. There's different considerations to take into account when taking silk, because your practice will differ completely, and also your income. Regarding the challenges at the Free State bench, I haven't encountered that many challenges at present. I would say that the problems with the RAF, Road Accident Fund, seems to be an issue. It also has a direct bearing on payment for junior counsel at the bar, because they, for years, haven't been paid their fees while appearing in court on behalf of the RAF. So that is a challenge. The problem will have to be solved within the RAF, within the Road Accident Fund. Because if you have a look at the court rolls at our division, I would say approximately 80% of our trials, which usually start on a Tuesday, is RAF matters. And often there's just no appearance on behalf of the RAF, or the RAF concedes the merits on the day of the trial. So there have been several steps and procedures put in place to regulate and to try to speed up trials and cases on the trial rolls. But presently, I think the most urgent matter is the RAF matters. I hope that answers the question.
MEC, I heard you say something that suggested that might have been your only question, but I'm not sure. I'm checking with you.
Yes, CJ, I was intending to ask that one question, but I think that MEF and Rhyn didn't capture on many of the challenges that are known that we are having. The issue of cases that are being postponed and dragging for long.
Or you want to ask a second question?
Yes.
Okay, all right, go ahead.
Advocate Van Rhyn, in the Free State, there are complaints about cases that are dragging too long and that are discouraging victims to continue with their cases, hence they would drop them along the way and not continue with the case. Particularly cases that are on gender-based violence and femicide, and cases of families where one of their members would be murdered. So they suffer a double trauma of being victims, but also victims of a delayed justice. So I was asking this question because you would be now at a very senior level. You'll be part of the people who are taking decisions to transform the judiciary system and make it to be effective and efficient to respond to the cases. One other thing that has been raised as a concern is the cases that are to do with children in conflict with the law. There is a complaint that there is racism at play in such cases because the white children are always referred to be under the supervision of the parents, whilst black children will be referred to either correctional services or the social development secure centers. Now, those are challenges that are there. The last one that has to do with that we are struggling with as the Department of Social Development, working together with the magistrates courts, is the issue of the foster care cases, where at the moment we are sitting with a backlog of 5,943 cases. And when I inquire, it is said that it is because we also rely on the dates that we are supposed to receive from the courts. So should you be considered, how will you deal with all these challenges that we don't experience them? Thank you very much.
Thank you. Firstly, there's pressure on the judges. I felt the pressure to finalize the matters allocated to me. Not pressure that I couldn't handle, and I'm sure the other judges as well, because it is our duty to do that, to finalize the matters allocated to us, and that includes criminal matters, but there's different considerations at stake. It's not only the victims of a crime. You also have to take into consideration the rights and privileges of an accused, and that is how you arrive at a fair trial for an accused, because an accused right is enshrined in our Constitution. What I've done, practically what happened to me in the motion court during the last term, last year, was a matter was enrolled on the unopposed motion court, and when I prepared for the matter and when the matter was called, it appeared that there was another application in the same file, and that application was not enrolled on the court, on the list. So what I did was I asked, not just to say what the matter is not on the court roll, I'm not going to hear the matter, so I asked that the case stand down, and that at the end of the roll, I quickly went through the second application that was also on the same case number. I prepared on that, asked the counsel, because they were both of them were there, for the applicant and the respondent, because it concerned two different applications. They addressed me on the matter, and I finalized both those applications on the same day. I do believe that the other judges of the Free State Division has the same philosophy, to finish the matters allocated to them. Regarding the issue of the children, the white children and the black, I think it's more a matter problems at the magistrates' court and at the district's court. I haven't encountered any of those problems. Yes, there's problems to finalize the criminal, also civil matters, but it depends on the rights of all the parties before the court. And you have to be fair to all the parties. Chief.
You are done, MEC, is that correct?
Thank you very much, Chief Justice.
Yes, thank you. Commissioner Kane, well, I was going to say you haven't raised your hand, but I wanted to give you a chance because sometime earlier I thought you wished to say something, probably in connection with the issue of silk, if I'm not mistaken. So I'll give you a chance before I go to Commissioner Nujesi.
Thank you very much, Chief Justice. Good afternoon.
Good afternoon, Commissioner.
What I really appreciated about your application was the report back from your colleagues at the bar who reported how thoroughly prepared you were and that you raised specific issues for debate in court, and you engaged so well with counsel. And that's, of course, as you know, what counsel always welcome from a judge. The aspect of your answers, though, that caused me some concern pertain to the question of silk and whether or not you had applied, why you hadn't applied. You've been at the bar for a long time, and even just counting the years with the Free State Association, it's now about 18 years. And my question is, it seems to me from your answers that you are ignorant of the Free State's process in relation to silk. And it seems that you've made no investigation in that regard because you don't want to apply. If I'm not correct, then you need to correct me, please.
Yes, it's not that I do not want to apply, but at this stage, and considering the fact that my work at the bar has diminished since my appointments as acting judge. You have to remember that while at the bar you have a private practice. If I'm not there, I do not earn an income, and the attorneys do not contact me while I'm at the bench when I'm acting. So for 6 months each year, my door's closed and my light is off. Taking that into consideration, I do not feel comfortable at this stage to apply for silk. Chief Justice remarked, and I do agree with that can be an attribute to say in my application, but I've attained more experience while acting as a judge. The further aspect is, if I do apply to become a silk now, I am jumping the queue of all the members above me on the list.
Well, let me engage with you on that issue, because the impression you've given now in this interview is that taking silk in Free State is just a long service award. In other words, when you finally make your way up to the top of the junior list, on which you now stand 13th, then you just wait about and silk may happen. That's the impression you gave me anyway. Yeah. And the procedure which I have obtained from the chairman of the Free State Bar says that a person who is a member may apply for silk at any time. Yes. Your duty is to collegially advise colleagues who are senior to you that yes. you intend to do so. That's and correct. We know the policy behind that is so that you don't leapfrog somebody who says, well, if you're going to apply, then so will I. Yes. And you respect that seniority. Exactly. But if the more senior colleague declines to apply, there's absolutely nothing preventing you from applying.
Exactly. That is exactly the correct procedure that we follow, or it depends on your own practice. If I feel that I've got a good practice, I'm actually doing senior work now, There's nothing that bars me from applying to become a
So
SILK.
you would agree then your previous answer to the Chief Justice was not a correct reflection of the practice in the Free
No.
State?
No. As I indicated in my answer, there's two applications pending. Both of them are not the most senior on the junior list. Both of them.
Have you actually read the policy document that pertained to the applications of taking of silk in your bar? Have you
No.
had a look at it?
No, I haven't had a look at it.
And that must be because you don't intend to apply.
I do not intend to apply at the moment. I've concentrated for the past 4 years now on the reason why I'm here today.
I'm sorry to intervene, Ms. Kane. Just on your last question, you don't intend to apply now, but it also means you have never intended to apply in the past.
No, I haven't. Prior to 2018, I did not consider applying for silk.
Yes, so your not applying for silk was not because there were so many people ahead of you. It was because you did not intend to apply. You didn't want to apply.
That's one of the reasons, yes.
Okay, please continue.
It's still a personal decision to make.
Thank you, Chief Justice. I think I should defer to other questions now.
Thank you. Thank you. I think you have certainly helped me because I thought there was something not right about this hindrance that I had. But before I go to Commissioner Nochesi, let me put this to you. My understanding of how you explained the position before was not that, or did not include saying that you are allowed to apply even if there are others who are more senior to you. My understanding of your explanation was simply that
I'm not the most
there
senior.
there are X number of people who are more senior to you. You have to wait for them.
Definitely not. Chief Justice, then I apologize for creating the wrong impression. The tradition is that the most senior on the junior list applies. But it happens, and that's why I explained that the two other members, who applied during, I think, last year, they are not even the most senior, the second or third on the list. They are more junior. So it's indeed, it's possible. It's your based on your own decision.
Well, let me say, I might not have heard you saying that the two who have applied are not the most senior.
No, they're not.
I heard that you said two have applied, and maybe I assumed that they were the most senior, but I didn't hear you say they've applied, they are not the most senior. But certainly the way you explained it on what I had didn't appear to leave room for somebody junior to say, well, I'm ready. If they are not ready, that's their business. I will apply and I'll just tell them and they can decide whether they want to apply or not.
The tradition at the bar is if you are not the most senior, you will inform those above you on the list of your intention to apply, and they can decide whether they want to apply with you or.
Yes.
But I've got the list with me, the seniority list, and the one member who applied is the seventh.
No,
from
that's
this.
fine. Commissioner Nochesi.
Thank you, Chief Justice. Actually, my questions were a follow-up to the Chief Justice's question, but I did not know how to deal with that. On 2 questions. In fact, before that, I must first commend you. Your judgment are well-reasoned, well-written. I've read through. You kept me alive even in this interview.
Thank you.
Now,
Thank you. Appreciate it.
two questions from me. They relate, the first, to the reported judgments. I took time at one stage to look. There are even judges who were more than 10 years as judges. They don't have the written judgment. Who decide on this reported judgment? Do you know what is the criteria? Who decide that a judgment must be reported?
I'm not exactly sure who decides, because it will be at Butterworth's or Judicial, who will decide whether a judgment should be published in the law reports. But because many of the judgments that we write as judges are quite similar to other matters.
Yes.
It's nothing new. It's just a judgment for a particular litigants that you provide. But it's not something of interest or important concerning the law for other legal practitioners. So there obviously will be more constitutional court judgments available in the law reports than judgments from Western Cape or Northern Cape. If it's a matter of specific interest on a specific subject, then it will be published.
Okay. So it's obviously it's not your fault that judgments are not.
No.
Now, the second question is this silk issue. From my perspective, in any way, this is a colonial concept which was limited to mainly male, white in the profession for many, many years.
Yes.
That is, and it was intended it's more related to fees in most of the time. Now, if you don't have a client base that is strong enough, would it be advisable for you to apply to be silk?
No, because taking silk has certain responsibilities. It usually entails that your practice will change dramatically. You don't get the normal matters. It's difficult matters, not only regarding the facts, enormous amount of facts. It usually files and files and files of leverage files containing evidence. And that's why when it's a senior counsel, they also employ junior counsel, maybe more than one, to assist them. So it has a huge implication on your fees as well. But it doesn't bar a junior member, I'm a junior member of the bar, to do more difficult work. I did a matter, I was instructed by the State Attorney's Office in Bloemfontein, a medical negligence matter. I received instructions to appear with a silk from Durban. We consulted, we did opinions, we did the pleadings, and at a certain stage, I received information, or I was informed, that the senior is not available anymore. And I was asked, do you want another silk to assist you, to lead you in this matter, or are you willing to proceed with the matter on your own? And I finalized the matter on my own. Yeah. So in actual fact, I did the work that the senior was supposed to do.
Thank you very much. That's the question, and I'm done. Doesn't matter that you have 50 years in practice, 60 years, not applying for silk. Doesn't really matter in any way.
I agree, and that's why I try to explain that it's not like going to school, but you never reach grade 12.
Okay. Thank you, CJ.
Thank you, Commissioner Nochesi.
CJ, I was going to say, let us close on the issue relating to the Bar Council's rules and all those, because I don't see the extent to which it might
No.
be relevant.
No. Commissioner Pillay, I don't know whether you were raising a hand or not really. Oh, okay. Please go ahead.
Thank you, Chief Justice. Good afternoon, Ms. Van Rhyn.
Good afternoon, Commissioner.
May I ask, in relation to one of the questions posed by the CJ around your reported cases,
Yes.
you referred to 2 cases. Am
Yes.
I correct? That's listed in paragraph 6.4 of your application.
Yes.
That's the Van Zyl versus Engelbrecht matter and the
It's criminal matter.
criminal matter.
Yeah.
That's correct. Now, in both of these matters, if I understand it correctly, and please you must correct me if I'm wrong, let's take the first one, the Van Zyl matter.
Yes.
You were led in that Van Zyl matter.
No, I was not led in the matter. I appeared in court in that matter on my own. There was a senior advocate, I believe from the Eastern Cape. He passed away in the meantime. But when I appeared in court, I was on my own. My
Right, so
heads of argument was only my work.
Okay, so you drafted the heads and,
I did the heads and I appeared in
and
the
you
matter.
appeared. Okay, so the law
Yeah.
reports are incorrect.
They're incorrect, yes.
All right. And then let's look at the second matter. That's the criminal matter.
Yes,
That's the matter where you were approached at the last minute by the Bar Council.
indeed so,
And
yes.
you filed heads
Yes,
and appeared.
yes.
Did you appear in that matter on your own?
Yes, I appeared on my own in that matter. I did. There was
Because again, the judgment refers to another advocate, I forget the name, but from
Yes.
from
But
the,
I was the amicus curiae in that matter, so there was counsel on behalf of the other parties as well.
No, I accept that. I accept that you are an amicus. What I'm putting to you is that the judgment refers to 2 counsel appearing for the amicus.
No,
I just
no.
wanted to be clear about that. Someone from the DPP's office, and
Yes.
then they list you as the second counsel appearing for the amicus.
No, I was the only one.
All right. Now, in relation to that matter, let's start there, because this is one of my crucial questions that I have for you. Did you choose to bring a junior into the matter?
No,
'Cause you had this
I
opportu-
wasn't the senior, so
I'm sorry, now I'm really confused. So you were in the matter, right?
is
Asked-
that now the criminal
the
matter?
criminal matter?
Yes.
In the matter, you have been requested by the Bar Council to make submissions on a pro bono basis.
Yes.
It's an important matter, and possibly a matter that would be a precedent-setting matter, right?
Yes.
Because they're figuring out the mechanics of the act.
Yes.
Now, when you get the request from the Bar Council, do you decide to bring in a junior in that matter? That's my question.
No, you have to remember that was a long time ago that I
Yeah.
appeared in that matter. And it will actually mean that there's 2 juniors then appearing as amicus curiae in the same matter. But it wasn't that complex that I felt the need to even ask a silk to appear with me in that matter, because that would have been more appropriate to ask a silk to lead me in the matter, not another junior.
All right, let me ask a question related to that then, Ms. Van Rhyn. Have you led juniors in your practice?
No,
You've never led any juniors?
no.
All right.
I apologize for interrupting. It depends on instructions from your attorney and from financial implications. So it depends on instructions from the client.
But with respect, Ms. Van Rhyn, here you have a perfect opportunity. You have a request from your Bar Council to appear in an important matter.
Yes,
The request is a pro bono request, so there's no financial implication
there's
one way
no.
or the other.
Indeed so.
It's a perfect opportunity for you to bring in a junior. Firstly, to get
Yes.
exposure on the
Yes.
matter, but
Yes.
also then for you to transfer skills to that junior in how you put together the submissions and then present the submissions before court. So your explanation doesn't explain why you wouldn't have brought a junior into this particular matter, and that's all I'm putting to you.
I understand. At that stage, it was, as I indicated, it was on short notice. I had to go through the work to decide thereafter, listen, I need assistance in this matter. It wasn't enough time. It didn't even cross my mind. I just needed to prepare to appear in court.
You see, Ms. Van Rhyn, I don't want to open up a topic I dealt with one of the earlier candidates, because I have a very substantive issue I need to turn to now, and I know the CJ is going to give me a look, but it's an important issue which I need to get to now.
Yes.
But earlier, I raised on one of the other candidates the plight faced by black women juniors at the Free State Bar. So in that context, it strikes me as, with respect, difficult to comprehend why, when you're presented with an opportunity to get involved in an impact-setting matter, that you don't even consider bringing in a junior, whether it's a black junior or another junior. I can't reconcile the two.
I understand, because that is a challenge to empower women at the bar. The circumstances in that matter is different. That will be my answer. It was on short notice. It was a pro bono matter. I had only a few days to prepare for the matter and then appear in court.
The last thing I'm going to say is, because it's short notice and you've got little time to prepare, there's more of a reason to bring on someone to assist you. But I want to go to the Nkuna matter. Can I ask you to open up your judgment? It's at page 100. CJ, with your leave, I promise you I won't be long.
Okay, last one.
Last one, page 100 of your bundle.
Can you please repeat the page?
100. It's the Nkuna matter. Now, while you're looking for the page, let me just set the background. This is a matter in which 3 applicants were arrested by security firms, private security firms, and they claimed to have been assaulted, they were detained, and they were eventually imprisoned. And they brought this application for, amongst others, damages for unlawful arrest, unlawful detention, for damages for the assault, and then for malicious prosecution.
Dana, where's page 100? I apologize.
No problem. You recall the matter, though, while they're finding your page. It's one of the judgments which you've put up.
Yes.
The Nkuna matter. So I just want to, while you're looking, cover the dates, because that's important. The assaults, the arrest, assault, and detention happens around the 16th of April 2012. The 3 persons are then detained. They get released on the 24th of June 2015. Some of them on the 24th of June 2015 and others on the 21st of June 2017, right? Yes. And then they institute this action on the 21st of May 2018. So obviously from those dates, the big issue that you have to deal with in your judgment is prescription. Yes. Right. Now, I just want to go through your reasoning on the prescription, because you know that what transpired in this matter is that the plaintiffs, or the applicants as you call them, the applicants claimed that prescription was interrupted by virtue of a number of facts, right? This was the incarceration. We know that they were indigent persons, so they claimed that they were in a dire financial position.
Yes.
They also claimed a lack of knowledge, correct?
Yes.
Whether or not there was a valid interruption of prescription. All right?
Yes.
And ultimately, before I get to ultimately, I want you to go to page 107 of your judgment at paragraph 17. And I just want to draw your attention to this crucial fact. The applicants tell you, and it's reflected in your judgment in the middle of paragraph 17, the applicants tell you that the Legal Aid Board refused to assist them. And without financial means, they were not able, before they eventually secured legal representation, they were not able to secure any legal advice. All right?
Yes.
We know that the legal aid steps in to assist them with a criminal matter, but never really with a civil matter until they enter into a contingency fee arrangement with a private attorney.
Yes.
Right. When you assess all of this, which is what you see from paragraph 18 of your judgment, all right, you go through the Lombard decision, which was distinguishable because it relates to facts where the person was outside of the country, incarcerated outside of the country.
Yes.
But if you turn to paragraph 22, you then do refer to a judgment which is directly relevant. And in that judgment, the SCA says and they're guiding you on interpreting Section 13(1) of the Prescription Act, right?
Yes.
And the SCA says to you, the word impediment therefore covers, sorry, I'm reading now the fourth line from the bottom of that paragraph.
Yes.
The word impediment therefore covers a wide spectrum of situations, ranging from those in which it would not be possible in law for the creditor to sue, to those in which it might be difficult or awkward, but not impossible to sue. In short, the impediments range from the absolute to the relative.
Yes.
So what the SCA says in this judgment is that you've got a wide discretion to consider, taking into account all of the relevant factors,
Yes.
whether or not what is presented to you constitutes an impediment for the purposes of Section 13(1).
I understand. Yes.
Let's go to how you apply it then. You say the applicants in the replying affidavit stated that their detention restricted their movements, restricted their contact with family and friends. I've already shown you paragraphs in your judgment where you recognize that they were in dire financial straits, that they had lack of knowledge, that they weren't able to access legal aid. All right?
Yes.
And you then conclude that, you say that at the bottom of that paragraph, they were not able to.
I'm sure you are wrapping up.
Yes, I'm wrapping up.
Pillay.
I'm almost at the end.
Okay.
That the only other reason they proffer was their financial position. Despite all of this, you conclude in paragraph 24.
24.
That 24.
Yes.
You conclude that their claim is prescribed.
Yes.
And you say it's because they were not detained outside South Africa. So in other words,
Yes.
you're applying Lombo.
Yes.
And the circumstances did not prevent them from personally pursuing an action. Now, all I want to understand from you is we have the SCA judgment that gives you this broad discretion,
Yes.
right? You have indigent litigants before you
Yes.
who say to you that they have absolutely no access to legal assistance, all right? Despite all of these factors, you still apply Section 13(1) in such a way that you close the door to these applicants.
Concerning
So I just
those
have-
claims, yes.
Yes. So I just have two questions. The first is whether, in your view, you properly applied APB, the SCA decision, right? That's the
Yes.
first question.
Yes.
And secondly, whether, when interpreting Section 13(1) and considering the facts, whether you properly applied Section 39(2) of the Constitution.
Understand.
Yes.
My answer is yes, I did properly apply the principles in that case referred to, and concerning the prescription, and regarding the issue whether I should have taken more consideration due to the fact that the applicants were incarcerated. The facts of that matter was that the real issue was the accused in the criminal trial was presented by an attorney and a counsel during the trial. So they had access to legal advice. That matter went on appeal. There was an application for leave to appeal. I granted the leave to appeal. The matter went on appeal, and I have with me the judgment of the matter when it went on appeal. It was a judgment heard on the 3rd of February 2020. It was delivered on the 20th, a judgment by Judge Daffew, at that stage the acting DJP, and he considered, the court considered my judgment and found that it was not faulted with my judgment. I've got the judgment with me. I can refer to the specific paragraphs regarding prescription, findings made on appeal. So I'm confident that my judgment was correct on all the aspects in that judgment.
I think let's
Thank you.
leave it at that.
Just to point
I can
out
see
that-
you don't agree.
No, because an appeal and an appeal against an exercise of a discretion is different from whether or not the exercise was correct in the first
Yeah.
place. But
Okay, all
no
right.
further. Thank you.
Thank you. I'm going to go to the commissioners who are attending virtually to see if they have any question. We have taken quite long. Commissioners attending virtually, is there anybody who
No
has a
questions,
question?
thank you, Chief Justice.
No questions from you?
No question.
Thank you. Commissioner Barnett, no question from you as well?
Yes, no questions, Chief Justice. Thank you.
Thank you very much. I think we have come to the end of the interview then. In case there are 2 or 3 points that you would like to emphasize and ask the commissioners to particularly bear them in mind as they consider your candidature, I give you 2-3 minutes to emphasize them, but if you say you are satisfied that all issues have been
all the members of the Commission, I truly believe that all the matters have been dealt with. My questionnaire is here. I've made myself available for questions, and I trust that
Yes.
concerning the criteria for appointments, it's my honest belief that I fulfill all the requirements.
Yes. Thank you very much. You are now for availing yourself.
Thank you, and thank you to the
Thank you.
commissioners.